Hi, welcome back. We're now talking about copyright. And remember, this is a survey course. I just want to introduce you to the four main areas of intellectual property law, or the four types of intellectual property rights. First we have, and I bundled them together, trade secrets and patents, because it's two different ways of protecting your ideas. Although trade secrets are easier, there's no registration, it's more broad and includes recipes and formulas, any idea that has commercial value and that is kept secret. Then we saw trademarks, right? And we saw that there's really the best type of trademark when you're trying to brand a product and obtain legal protection for your product is going to be an arbitrary or fanciful mark. At the very least, a suggestive mark. Now let's look at copyright law. Oh, and by the way, with trademarks, we also saw the standard for infringement is likelihood of confusion. So now let's do copyright law. And I want to go back to that original question I posed in my introductory video, but I'll repost it here in case you skipped the video or forgot. Have you created any intellectual property? And frankly, you might want to say, well, no, getting a patent, it's very expensive, right? It's a formal process. You saw the Google patent earlier in module 4. A trade secret, maybe you've had a good idea. Maybe you have a family recipe or a recipe that you've concocted, right? But have you shared it with anybody else? Have you posted it on the internet? Have you emailed it to someone without getting a non-disclosure or confidentiality agreement in place, right? But maybe you've done a trade secret or had an idea that could potentially be a trade secret. What about a mark, a trademark? Have you come up with something totally arbitrary, fanciful, suggestive? Maybe you have. But let me tell you, it turns out that every single one of you have, in fact, created intellectual property. At a minimum, you've probably created, today alone, several works to which you own the copyright to, the common law copyright. And if you've taken a selfie on your phone today of yourself or of something else, if you've written a love note, if you've written a poem, a doodle, drawn something, composed a song, all the essays you've done in this course up to now, all the discussion posts, that is your intellectual property. The profile pic you posted, assuming it's a picture that you took yourself, that is your intellectual property. And that's what's really amazing about copyright law. Although copyright law does not protect the substance of an idea, that would really be the job of trade secret law or patent law. But copyright law allows you to protect the expression of your ideas. And all copyright law requires, and copyright law, I should say, it is protected by federal law, but it originates in the common law. Again, like trademarks, you don't need registration. And unlike trademarks, you don't even need to be in commerce. All you have to have is, an idea that you express somehow. What copyright law, going back to common law days, requires is that you create an original work and that work is affixed in a tangible medium of expression. Tangible medium of expression. The moment you jot down an essay on a piece of paper or on your computer, the moment you take a selfie, you automatically have a common law right, a copyright, literally, in the picture, the doodle, the poem, the love letter, the picture, whatever it is that you created. And so I really find this very, very exciting that we all have the ability and we all have, in fact, created intellectual property rights. But now let me explain why registration is recommended, federal registration, whether we're talking about a trademark or whether we're talking about a copyright. Let me first back up and reemphasize the main point. If you have a mark that's suggestive or fanciful or arbitrary, right, and you're using it in commerce to distinguish your products or services, you automatically have a common law trademark right. Again, if you write an essay, compose a song, write a short story, take a picture. You automatically do a choreography for a dance. You can jot it down somewhere. You automatically have the common law copyright, the legal rights to that expression of the idea. As long as it's sufficiently original, you know, you're not just copying it from somebody else, or it's not substantially similar to somebody else's idea or expression of their idea, and it can be affixed in a tangible medium of expression. If you meet those requirements, you automatically have a common law copyright. But the reason why, if you're in business, why you may want to take the time to actually, you know, consult an attorney, IP attorney, trademark or copyright lawyer, and consider registration of your trademarks and copyrights is because registration provides you several advantages. Advantage number one is that if your registration is approved, whether it be by the United States Copyright Office and the Library of Congress or the United States Patent and Trademark Office, the USPTO, that is dispositive proof that you are the legal owner of the copyright or the trademark. That is automatic proof that you are the legal owner. Whereas if it's just a common law trademark or a common law copyright, something that you created, you're going to have to come up with evidence of, you know, well, when did you create this? You know, when did the right, when was that right created? But with registration, right, that's a formal process, and registration confers, you know, automatic ownership rights to the registrant. The other benefit is now the federal courts are open to you if somebody is infringing on your trademarks or copyrights. So registration, what it does is it takes your right from a common law right, which would force you to go to state court to protect your rights. And state courts, I haven't, you know, because of the pandemic, you know, courts are closed. I haven't asked anybody to go to a courthouse and sit in. But one of the things with state law and state courts, we'll see this in Module 5, is they have very congested dockets. You know, federal courts tend to be lighter dockets. There's only a few areas of federal law in comparison with state law, and federal courts are therefore faster. So federal court enforcement. Third advantage is now, even if you're only doing business in Orlando, Florida, or let's say you're Mark Zuckerberg and you're only doing business, you know, your website is only operational at Harvard College, or let's say you're Carol Baskin and you only have one wildlife sanctuary in Tampa, Florida. The moment you get registration, without registration, your common law rights really only extend to that market in which you're doing business. Yes, you have common law rights, but only where you're doing business. With registration, even if you're only doing business locally on a small scale, you automatically get nationwide protection. Your rights extend across the United States. So that's an important advantage. And fourthly, just to emphasize the big advantages of registration, is it's easier to prove damages. For example, in the case of copyright law, the copyright law will establish what's called statutory damages, where you can just say, look, if somebody has infringed or, you know, taken a copy without authorization of my work, I can sue them for X amount of, I can automatically recover X amount of dollars depending on the work that's being infringed and depending what's in the copyright law for each instance of infringement. And so, you know, you don't have to, normally, like in tort law, you have to prove your damages, you have to prove what your injury is. With federal registration, it's easier to prove, you know, not just to prove infringement and that you're the owner, but also to prove, to get a remedy, to get money damages as a way of compensating you for the infringement. So there are lots of advantages to registration. But now what I want to do is, whether we're talking about a common law, you know, copyright or a common law trademark, you know, or one that is federally registered, I do want to talk about infringement, right? That was my other question. How many of us, what I really should have asked is how many of us have not infringed on anybody else's intellectual property rights, right? Especially their copyrights, right? Very easy to, you know, cut and paste things from the internet. A lot of things on the internet are copyright protected or are, you know, supposedly copyright protected. So what I want to talk about in my next video is the fair use defense. Very important defense. I'll see you on the other side.